How's it going, everyone? Really interesting chapter or module, I guess you could say. I'm going to adjust the screen a little bit, but HIPAA. If there's really one federal regulation that people know about more than anything else, it's HIPAA, confidentiality. You know, it's really, really important for healthcare caregivers to know, and for anyone involved on the outside of things. You know, if you're a patient, you should know about HIPAA because you should know your rights. Let's jump into it. This is from the Hippocratic Oath, and I'm sure you're aware that every provider has to recite the Hippocratic Oath. They swear by it. What I see or hear in the course of treatment, which on no account must be spread abroad, I will keep to myself. So it's really highlighting the need of privacy and confidentiality. I will say, though, providers are usually pretty good about this, but sometimes there are things that gets out that can be negative or damaging to patients. The website I found in regards to what are the most common HIPAA issues that are out there. Keeping unsecured records is one. These are the 10 most common. Unencrypted data. So encrypted data means someone can't get into it without secure password, really digging deep down into it. You can get into encrypted data, but it's a lot harder. Hacking, you know, you have a lot of hackers out there that could definitely get into your electronic public or electronic patient health information, EPHI, loss or theft of devices. You know, that really has to do with you know, doctors, providers taking their computers home with them and then someone hacking it. Lack of training, that's a huge thing. HIPAA is now a big part of training at large hospitals, large organizations, so you have to know what HIPAA is. And first off, let me explain something really quick. It's not HIPPA, it's HIPAA, and hopefully you know what that stands for. We'll talk about that as slides go on. Gossiping is another big thing. Please don't post on social media anything in regards to health information. That's not smart. It's not a good thing to do, and will get you fired from just about any hospital or any private practice. Employee dishonesty happens sometimes. Improper disposal of records. You should dispose in a shred container any records that are not to be kept within the facility, and it's the proper kind of shredding. Unauthorized release, and then third-party disclosure of PHI. Third party would be a health insurance company or a different company outside of the person themselves, the hospital. It's someone seeking health information, and sometimes this can be disclosed in an improper manner. So really flew through those really quickly, but that's just some examples. It is necessary, of course, to preserve the dignity of your patients. Think about a patient that comes in, has mental health problems, and tells the provider in confidence. So mental health practitioner, for example. And then if that provider starts spouting out that information to everyone, you know, their livelihood as the patient could be ruined. That is a really, really dangerous thing. So keeping things safe, keeping things confidential, it's very, very key to professionalism, and it's very important. And we talked about this. Patients have to sign for approval for their medical release. You also have to have a release of information for any person speaking on your behalf or power of attorney. It's really important that you don't talk to health information to a spouse if they're not released for that information. The patient has to release the information. No one else can do it unless it's a federal requirement, like, for example, flu. If you have the flu, you have to report that to the state health board, so they know how many cases are out there, and the CDC also keeps track of that. That's the Centers for Disease Control and Prevention, and that's the hub of that is located in Atlanta, Georgia. HIPAA policies. Let's talk a little bit about HIPAA. The Health Insurance Portability and Accountability Act of 1996, HIPPA. No, wrong, HIPAA. You can tell how easy it is to get that confused. People have messed that up for years. It was signed into law in August of 1996, and it really regulates privacy and health information. The goal of this was to reduce healthcare costs by streamlining the healthcare system. In 1996, there was a lot of other acts that went into play. I'll point one out really quickly. Budget Act, it says 1999, but it really came into play in 1997. 1996 really was when a lot of different healthcare elements came into play. It created critical access hospitals, and I have a lot of experience in this because I worked for a critical access hospital. But HIPAA happened at this time. Balanced Budget Act happened at this time. They really tried to control healthcare costs. So part of the plethora of the Balanced Budget Act was to help incentivize rural hospitals so they could stay open and serve and care for people within their community. Just a fun fact in regards to different legislation that is out there. Critical Access Hospitals, the acronym is CAH. It's hospitals under 25 beds. So really small hospitals, a lot of small hospitals in Alaska, hence why I know a little too much about that. Health insurance, of course, it should be portable for providers and also for patients who need their healthcare records. Part of this HIPAA regulation was to decrease fraud. I wanted to make sure that people weren't selling healthcare information, weren't accessing it when they shouldn't have, and there's a lot of different instances in there that simplified or changed this. Only covered healthcare entities could see protected health information, and this has a lot to do with electronic versions of healthcare information. Electronic medical record, acronym EMR, and electronic health record, acronym EHR, is a big thing that you see in healthcare today. A lot of different hospital systems, a lot of different clinics have EHRs. You have to in order to get reimbursed for the federal regulation side of things. So HIPAA comes into play quite often. The privacy rule, PHI, protected health information. I said patient earlier. I apologize for that. It's actually protected health information. Sometimes I even confuse the acronyms because in healthcare, as you will find out, there are so many acronyms, it's hard to keep up with. Luckily, we have Google nowadays, and we have search engines that can help us, remember a lot of it. But protected health information really was highlighted in the HIPAA legislation, and notice of privacy practices was as well. So you have to have a notice of privacy practice before you see a patient, so the patient knows that their health information is going to be protected. Lots of great information. Here's the patient rights under HIPAA. What does patients have access to? They have access to their medical records if needed. That is a cover sheet for certain information though. Mental health data, sometimes patients cannot access their mental health data. The only reason being is if the provider views it as a negative detriment to their future health. So if someone has a mental health condition, and if they see that they have a mental health condition, it's going to make matters worse, they're going to hide that from them, the provider. That is completely legal. You're acting in the best interest of the patient, so it's a little bit different. Release of information, you have to have a release for information in order to release information from the medical side of things. Providers cannot refuse treatment if a patient doesn't sign a consent form, especially in the emergency side of things, but there are exceptions. They can refuse treatment. So let me just get that right, not can't. Can refuse treatment. If it's an emergency situation, they cannot. If there's a language barrier, they cannot. We have to have interpreters at large organizations, as you might be aware of. And then smaller organizations are also legislated to have interpreters as well. Prison inmates as well, you have to provide them medical care. Denying requests, some healthcare institutions can deny access to a patient's medical record. We talked a little bit about that. This also deals with, and I put some information on your module, it also deals with pregnancy-related issues, STDs. If a patient that's a minor goes in for this treatment, they can actually sign for consent without the parental guidance or parental signature along with them, and you have to protect that information from the parents as well. There's some covered entities under HIPAA. As you can see, there's quite a bit. SMF and F stands for skilled nursing facilities. It's a nursing home per se. It's a little bit different than a home health organization or a long-term care facility. You have to have an EID number, of course, employee tax ID number, and an employer identification number. You don't really need to know that, but just a unique identifier for healthcare providers. Patients also have medical record numbers, so that's something that's used to protect health information as well. You don't go into the room as a provider and say, I pulled up Becky's chart. you have a medical record number associated with each patient, so you can keep things private. And it's usually a pretty long, lengthy number, not number 1 or number 2. It's usually 0012, blah, blah, blah. It could be a variety of different numbers. This is all a part of health information that's protected, patient's name, address, email. It's not per se health information, but it's protected information under HIPAA. Of course, your social security number, your medical record number would be one because it is identifier strictly to you. However, we use that in conversations in the healthcare setting to de-identify as well. Some obligations under HIPAA that you should be aware of. I'm going to kind of move forward because I know we only have about 5 more minutes. There are serious penalties if issues do happen. You're looking at $25,000. And a lot of it's minimum. It says $100, but you really rarely see that with healthcare institutions. They're usually federal crimes associated with HIPAA violations. So I've seen issues and lawsuits out there for hundreds of thousands of dollars. So this is a serious matter. It's taken very seriously on the court setting of things, and it should be for our sake as well. Here's some more patient rights under the privacy standards. Really interesting to me is the one that states, examine and copy health information the provider has recorded. Yeah, you can look at health information if the provider recorded it, of course, and it's available for access. And you can actually state contradictory facts in your medical record, and then the provider has to either blot it out if it's an issue or if it was wrong, or write kind of background information regarding it. Some clarifications of HIPAA. It does not prevent hospitals from disclosing names of patients to clergy or from keeping patient directories. We talked a little bit about that with the flu side of things. It does allow hospitals and physicians to share information with the patient's spouse, family members, or friends, or anyone the patient has identified as involved in their care if they have a release of information. Let's be clear on that. It doesn't limit EMT disclosure of information because that's an emergency situation, and they should be able to disclose information to the healthcare provider once they deliver you to the hospital. When we talk a little bit about ethical concerns related to technologies, there's a lot that goes into that. Telemedicine is huge now. If you're not aware of telemedicine, I would recommend doing some research. Really interesting things that are happening with telemedicine, especially virtual care. A form of telemedicine is the teledoc that's out there. So when you go on your cell phone and you have an issue where you have a sore throat and the doctor sees you on the cell phone and you tell them your symptoms, that happens nowadays. That's a form of telemedicine. Telemedicine was also used to communicate with rural locations for people that didn't have providers. They would set up a machine if they had Wi-Fi connection and connected them remotely. Really, really interesting. I think really, really cool as well. Here's some precautions. The main thing with HIPAA is to use common sense. Make sure you have secure platforms, secure servers. Do not leave patient information open on the counter or your desk. Don't share your computer passwords because they're going to be able to access electronic health record system sites if they have your passwords. Use software things. A lot of this has to do with the information technology side of things, the IT side of things. But it's really, really important that you take HIPAA seriously. HIPAA is legislation that it's defined very, very specifically. You protect health information at all costs. You make sure you do it in the right manner. And if not, you can be in trouble and held liable for that. I'm going to show you the HHS.gov or HHS.gov website on health information privacy. You have a platform of things you can look at in there. I recommend you taking a look at it anytime that you can. It's really, really, I think, intuitive. They've done a better job of helping people understand what their healthcare rights are. You can also see that it's really neat, there are other languages in here for people that speak different languages or can't read English or write for that matter. There's a lot of great things in here that you can access. So this is just a background on HIPAA, HIPAA, Health Information Privacy. and I hope you really take into consideration what it means. Take a look at the PowerPoint, read your text. If you need anything, let me know. I'm happy to help in any way that I can, but this is really important for all of us to know.